welcome to today's episode. It's the second episode in Privacy Engine series on international data protection legislation. We started off last week with the Indian Data Protection Law, or what we call the Digital Personal Data Protection Act of 2023. And today we're looking at the Kingdom of Saudi Arabia's Personal Data Protection Law, or what we call the PDPL. We'll break down the law in terms of what it does, how it compares to the GDPR, and what organizations need to do if they are preparing to be compliant with the law. I'm joined, like I was last week, by my friend and colleague, Katie. And like last week as well, we'll alternate the questions. So I'll start with the first question and then Katie will go on with the second question and so on. We have about 12 questions like we did last week as well. So hopefully this podcast will take you on a journey where you'll get a clear, engaging tour of one of the most important data protection laws in the Gulf region. What exactly is the Saudi PDPL and why was it introduced? So the Saudi PDPL, or the Personal Data Protection Law, is the Kingdom's first comprehensive privacy framework. It sets out how personal data must be collected, used, stored, shared, and transferred. And it gives individuals really clear rights that are very similar to the GDPR as well, and places obligations, very formal obligations on organizations in terms of processing personal data. And it's similar to other global privacy laws like the GDPR. It was introduced as part of Saudi Arabia's Vision 2030 digital transformation. And that's we can talk about that later on. I have information here about it actually. But the Saudi Arabia's Vision 2030 is essentially the kingdom's blueprint for economic and social transformation. And the digital innovation sits right at the center of this. So the idea is to shift the country away from purely oil-independent economy and build a modern, diverse, technology-driven society, okay? So the country is rapidly expanding cloud services, AI, fintech, digital government, and it has a massive smart cities project, which is called NEOM. And NEOM is like Saudi Arabia's flagship future city project. It's huge and it's in the northwest of the country near the Red Sea. It was created as part of the Vision 2030. And it's not just a city, it's more of a cluster of developments that are meant to showcase the ultra high-tech, low-carbon urban living and what that could look like. So the total of the NEOM area is 26,500 square kilometers. So it's not like a city, it's more like a small country. So that's really exciting. So, you know, the PDPL is a crucial part of that development for Saudi Arabia. So the law also helps to attract international investment. And before the PDPL, there was no unified data protection regime, which made global companies hesitant to come to the kingdom. The law, especially after its 2023 amendments, aligns more closely with international standards and creates a workable system for cross-border transfers. The PDPL also reinforces national data sovereignty, central oversight by the Saudi Data and AI Authority, reflecting Saudi's priorities around security, cultural norms, and responsible innovation. At the same time, it responds to growing public expectations by giving people their rights to their data, the right to access, the right to correct, the right to delete, and we look at those in more detail as we go through the podcast. And finally, the PDPL lays the groundwork for safe AI and data analytics, ensuring these technologies are developed within trusted, well-governed legal environment, and ensure it's not just a privacy law, it's a strategic foundation for Saudi Arabia's modern digital AI-driven future. Okay, so moving on to the next question then. Katie, this question is for you. Who does the PDPL apply to, both inside and outside of Saudi Arabia?
So the Act does have quite a broad scope. It applies to any organization that processes personal data of individuals who are located inside the kingdom, whether the organization is physically in the kingdom or operating from abroad. They include public and private sectors. And again, something interesting we had from our previous about the Indian law, it does extend to deceased persons as well, but in this case, only to the extent that it could identify the individual or their family members. So that's kind of quite an interesting common thread in this law, actually, that reflects the local culture of that area, that kind of they have quite strong family identities and reputations there. So it's just interesting that that comes in through the data protection law. And so other than that small detail there, it is basically identical to the territorial scope of GDPR. If you target or monitor people in Saudi Arabia, you have to abide by this law basically. Again, the GDPR only really applies to living individuals, so I'd say that's the main thing in the material scope to look out for. Um,
Yeah, exactly. And we've seen that now, like you say, with the Indian law and now with the Saudi Arabian law, that it considers deceased individuals as well in various different ways. But that's something that the GDPR has never considered, and even in the digital omnibus, it's not even thought about there. So that's
yeah,
interesting.
it
I
is
think
that.
it reflects kind of culture, I think maybe.
Yeah, I agree. I quite like that it extends to the extent that it could identify someone as well here, that it's kind of making that distinction, like it's kind of helping explain why we should maybe think about deceased persons data.
I agree. Yeah.
Um,
'Cause like you say, there's implications for the family, you know.
yeah, oh,
Yeah.
definitely. Yeah.
Yeah.
So, Maria, how does it actually define personal data? Does it have a special category data equivalent?
Yeah, actually, so like the Indian Act last week, we saw that, special category data doesn't exist in the Indian Act, but here in the PDPL, there is they do make that distinction. So the PDPL defines personal data in a very broad way. It includes any information that identifies a person directly or indirectly, not just names and ID numbers, but also behavioral data and device identifiers and employment details and location information can even be deemed as personal data. So any kind of information that can be linked back to the individual can be seen as personal data, which is interesting again, because when you consider the digital omnibus, now they're looking to change the definition of personal data in the GDPR, because they're now saying that certain pseudonymized data under the GDPR may not be covered by the GDPR. So that's interesting. So there's kind of like an opposite happening. Like,
Yeah.
the PDPL is very broad in scope, and whereas the GDPR seems to be reducing it somewhat, you know. The law then goes further by creating a category of sensitive personal data, which receives stronger protections. So again, like the GDPR, this includes health information, but it also includes financial data, which is not covered under the GDPR, special category data. It also includes genetic data, religious or philosophical beliefs, again, like the GDPR, ethnic origin and security related identifiers. So it's slightly different there from the GDPR. These categories are treated as high risk because misuse could cause harm or discrimination. And they also reflect cultural and national considerations specific to Saudi Arabia. Like, for instance, biometric data like fingerprints and facial recognition, it's given stricter treatment, with Saudi Arabia moving quickly into AI and digital identity and smart cities initiatives and so on. The PDPL requires organizations to apply very strong safeguards, obtain explicit consent in some cases, and conduct risk assessments before using biometric or genetic data, which is a good sign. Compared to the GDPR, both laws treat sensitive and biometric data as requiring extra protection. So that's similar to the GDPR. But the PDPL does within a more centralized governance model focused on data sovereignty and national security, as opposed to, what the GDPR would do. It's more like rights focused. So you could say in this respect, the PDPL is more controlled or prescriptive. So in short, the PDPL uses a broad definition of personal data. It treats sensitive and biometric categories as high risk and requires stricter safeguards when processing them, all reflecting the Kingdom's priorities around trust and governance and safe digital transformation. So Katie, yeah?
I was just going to say, I also, when I was looking through it, I noticed one element of the sensitive category data was also data that indicated one or both of a data subject's parents are unknown. So I just thought that was another interesting reflection of kind of the cultural relevance of family backgrounds in the area, which again, like in the deceased individuals, we seen reference to the family connections, and then under the sensitive category data, I just, they're kind of thinking about individuals in a wider context than individual, than the GDPR, I'd
Yeah.
say, which
And when you say when one of the parents is unknown, does that then become special category data or sensitive data, or how does that work?
well, it said what the data that indicates one or both of the individual's parents are unknown was included in the article that defines sensitive category data. So I
Mm.
just think it's almost more community based, like
Mm-hmm.
I don't know,
Mm-hmm.
than the European understanding of personal data. It kind of considers the community impact, rather than just the impact on the individual as well.
Yeah, okay. So if one of the parents is unknown, then that may be sensitive within her environment or her community, so his community. So keeping that private would probably help them, feel more comfortable in their community, maybe. Yeah,
Yeah, yeah,
yeah,
that's what I was just
yeah.
interesting. Another,
Yeah,
I don't know.
yeah, something different to the European perspectives. Yeah. And so probably something that's important for their culture that obviously wasn't important enough for it to be included in the GDPR. But yeah, that's interesting, an interesting distinction. Yeah. Okay, so Katie, the next question for you is, what are the main lawful basis for processing personal data under the PDPL? So last week again we saw the Indian Act, or the PDPD of 2023, being quite different to the GDPR. So is the KSA similar or the PDPL similar to the Indian law, or is it more similar to the GDPR?
Well, I'd say it's a bit of both and neither. I don't know. So the PDPL is consent first, basically, which is flipped from the GDPR. I mean, I feel like especially the supervisory authorities in Europe right now are kind of discouraging people from relying on consent as much because of, the consideration for the fact that consent may not be freely given in a lot of cases. So consent is the main basis for processing personal data under the PDPL. But Article 5 does say it needs to be explicit, informed, and freely given. It does say that the data subject can withdraw the consent at any time. So, I mean, it wouldn't really be consent, I suppose, if you couldn't. But Article 6 then goes on to allow a couple of different situations where you do not need the consent of the data subject. So they have the vital interests basis. They have actual interests of the data subject. They have where legal obligations, contractual agreement, for matters of security, judicial requirements, and they do have for the legitimate interests of the controller, but only where those interests do not harm individuals' rights or contradict the law's purpose. So they do have the concept of legitimate interest, but it is a bit narrower than the GDPR version now. It's only legal where there's no sensitive data as well, so they can't kind of mix legitimate interest for processing sensitive data, and they do need to complete an assessment. So, I mean, back to back, the GDPR encourages kind of taking a case by case basis when it comes to legal basis. They kind of don't want people to be relying on consent in every situation. Um, the PDPL is basically backwards and saying, consent first. And if you can't get it, then you need to fit into one of these other categories. So,
And I think it's interesting as well to say that, again, with the digital omnibus coming down the line, legitimate interest is going to be widened under the
yeah,
GDPR and the EU AI Act. So it would be really interesting to know, and I don't know this answer, but maybe we can look into it. But it would be really interesting to know how Saudi Arabia or even India justifies the processing of personal data in AI systems, because under the GDPR now, we're seeing that they're saying that you could actually use legitimate interest for processing personal data in your AI systems, which in my opinion could cause a conflict of interest for the DPO quite easily, but that's another discussion. But
true.
yeah, it's interesting.
Yeah,
Yeah.
yeah,
So the in the PDPL, legitimate interest does exist, but it's not as wide as the GDPR. That's interesting.
yeah. And you can't use sensitive data. We'll move on to the next question. So, Maria, what rights do people have under the PDPL?
Thanks, Katie. Well, I think again, so these are quite similar in my opinion to the GDPR. There, from what I can understand, there are 6 rights. So one of the key features of the Saudi PDPL is that it gives individuals a clear set of data subject rights. These rights are central to building trust in the digital services and supporting the kingdom's shift towards a modern, accountable data ecosystem, like we were saying earlier on. So people have the right to be informed, which means organizations must clearly explain what data they're collecting, why they're collecting it, and how it will be used, and who it may be shared with. So that, again, similar to the GDPR here. Privacy notices need to be transparent and accessible and not buried within legal jargon. Individuals also have the right to access their data. They can request a copy of the information an organization holds about them. So that again is like a data subject access request, which is especially important now that that more services rely on cloud platforms and AI systems within the kingdom. They also have so individuals also have the right to correct inaccurate or outdated data, which is crucial in sectors like financial and healthcare, because you can have serious consequences in those 2 industries. The PDPL also recognizes a right to request deletion, but this is within limits. So people can ask for their data to be erased when it's no longer needed, but in certain situations, organizations may need to keep some information for legal or security reasons. So again, that's very similar to GDPR there. Another significant protection is the right to restrict processing, something that we didn't see in the Indian Act of last week, but what it also exists in the GDPR. If someone believes that their data is being used unfairly or incorrectly, or if there's a legal process going on, then they can request the organization to pause processing until the issue has been resolved. There's also a growing expectation that individuals can challenge automated decision-making, even though I don't think this is a right yet, but there is increased pressure in looking into this area. The PDPL doesn't mirror the GDPR's Article 22, but it does require transparency around profiling and automated decision-making. It allows people to query or contest decisions that meaningfully affect them. So again, you're seeing, similar to what's happening with the GDPR, kind of credit scores and so on, those kind of things that have a serious impact on people's ability to access finance and so on. Again, in the kingdom in Saudi Arabia, they're looking into this and putting safeguards around it. Finally, individuals have the right to complain. They can escalate concerns to the Saudi Data and AI Authority, and the regulator, which has strong enforcement powers and can require the organization to corrective action. In short, the PDPL gives individuals the right to be informed, to access their data, to correct it and to delete it under certain conditions, to restrict processing, and to question automated decisions. And this is all aimed at increasing transparency, accountability, and public trust in Saudi Arabia's fast-growing digital landscape. So, next question now is for you, Katie. What obligations are organizations required to comply with under the PDPL?
Thanks for that, Maria. So they have a couple of different things to look out for. Under Article 8, they need to do their due diligence with their processors. They need to basically make sure that their processors have an adequate level of compliance in relation to the law. So that's a responsibility on them, much like the GDPR. You can't really claim ignorance as to what your how your subprocessors are handling the data that you give to them. They need to implement accountability measures, ensure accurate and minimal data collection. They need to have technical and organizational security controls. They do need to maintain processing records, which not every international law imposes, and which even the GDPR is considering taking out for certain organizations, which, I think that maintaining processing records is kind of essential to every other thing that you do in relation to your compliance.
I totally agree.
It just takes more work off you at the end of the day. It's easier. So yeah, they do have to do that. They have an obligation to train their employees, offer clear rights handling mechanisms for the data subjects. They do have impact assessments similar to DPIAs for high risk processing, new technologies, profiling, handling sensitive data, and then breach notification obligations, which we'll kind of talk about further on, I think, in a bit more detail there. So it's quite identical to the GDPR there. The Saudi enforcement does have a stronger emphasis on regulatory engagement, culturally specific expectations, like their notices have to be in Arabic, which, that's not so different when you consider that the GDPR notices have to be kind of intelligible. When you consider, the people who are going to be exercising their rights, they need. So I'd say, yeah, it is. It's almost one for one, compared to the GDPR.
You know how we saw last week as well with the Indian law that the data principal had certain obligations not to, not to be vexatious and so on. Do you have any idea whether that exists in the Saudi law, or is it very much like the GDPR in that it doesn't seem to put any obligations on the data subject?
Yeah, no, I don't think they do. I think as far as those three laws, the Indian law is unique in imposing the obligation on the data subject, which I actually like
I agree.
that
Yeah,
obligation.
yeah,
Um,
yeah.
Maria, what does the law say about international data transfers?
So I think it again, so we saw in the Indian law last week, completely different to the GDPR. The PDPL, in my opinion, is much more like the GDPR in terms of the fact that it has adequacy requirements. So international data transfers are one of the areas where the Saudi PDPL has changed most, especially after the 2023 amendments. The original version of the law was very restrictive. It basically made it difficult for organizations to send personal data outside of Saudi Arabia. So, but after 2023, they kind of made it more, they kind of made the act more, or the PDPL more modern. Because before 2023, it caused issues for cloud services, multinational organizations, and basically any kind of cross-border business models. So the amended PDPL from 2023 is much more practical and aligned with global standards. Today, data can be transferred outside the kingdom, but only if proper safeguards are in place, and that's again similar to the GDPR. The core idea is simple. Any personal data leaving Saudi Arabia must be protected to a level that isn't materially lower than what the PDPL guarantees inside the country. So again, you can see that as kind of an adequacy agreement that you would have to put in place or you'd have to have with the GDPR. Or again, standard contractual clauses. If you don't have an adequacy agreement, you'd have to get the standard contractual clauses in place to make sure that the data has the same level of protection outside as opposed to inside the country. And there are a few ways organizations can meet that threshold. They can transfer data to a country that the Saudi authority has deemed adequate, or they can use strong contractual safeguards, again, similar to the SCCs in Europe, like the PDPL compliant transfer agreements that they have. And for very specific situations, such as fulfilling a contract or protecting someone's vital interests, the law allows for limited exceptions, which again are similar to the GDPR. So what's unique about the PDPL is that its emphasis on the national data sovereignty. Organizations must show that the transfer is genuinely necessary and that they've limited the amount of data leaving the kingdom. The Saudi authority also keeps central oversight and can approve, restrict, or block these transfers, especially when sensitive categories or national security concerns are involved. So while the GDPR and the PDPL allow for international transfers based on adequacy, their philosophies are slightly different. The GDPR is driven by protecting fundamental rights, as we know, across the borders, while the PDPL focuses on ensuring that the data leaving the kingdom doesn't undermine the national governance or cultural or security priorities of the country. So yeah, so kind of fundamental philosophical differences there between the two jurisdictions. So Katie, tell us about the requirements for consent and privacy notices under the PDPL.
Okay, so I mean, as I said earlier, consent needs to be explicit. That you need to obtain the consent before collecting or processing the data. And individuals need to be able to withdraw their consent at any time without negative consequences. I suppose without negative consequences, that kind of considers that point that the European perspective of why consent may not be appropriate in all circumstances. Um, but so it's Article 12 and 13 that talks about the privacy notices in particular. They need to be clear, accessible, and usually in Arabic. Um, they need to be provided to data subjects prior to the collection of their data. And it needs to outline the controller's identity, the purpose of processing, the legal basis they're relying on, how long the data is going to be retained for, what rights they can exercise, whether the data is going to be disclosed to a third party, how someone can object or withdraw the consent. Um, it needs to inform them of their right for complaint, and it also needs to explain whether the data is mandatory and what could happen if the data subject declines to share that information. So, I suppose everyone might want to exercise their right to not share data, but I mean, in some circumstances, that might actually have an effect on your experience of a particular service. So, interesting addition. But yeah, overall, the transparency expectations are quite similar to the GDPR.
Mm-hmm.
Um, Again, the language emphasis, but I mean, it's their country, their language. At the end of the day, um,
Absolutely. Yeah.
and it also requires that it needs to be accessible to individuals with varying levels of digital literacy, which I quite like because, I mean, I know just personally, some people in my life have no concept of, what the repercussions could be of giving their consent to something or withdrawing their consent, and you can't blame them either because it's just not everyone's, ballpark. So,
Absolutely, I agree. And that sounds to me like the protections that are in place in the financial industry, where if you sell an individual a financial product, you have to be sure that they understand what they're buying, you know. So again, that would be kind of financial literacy and understanding what you're getting into. I think it's very similar in the digital age, like giving consent, but they have to understand what are they giving consent to. Like
yeah,
you can give them a whole load of jargon and kind of befuddle them and confuse them, and that's not explicit consent in my opinion.
I
So
agree.
digital literacy is essential in terms of making sure you have explicit consent. So that's a good point.
Yeah, it's quite a good point. So we'll move on to the next question for you here, Maria. How does the law treat AI profiling and automated decision making?
Okay, so this is an interesting question as well, because again, we've seen, like we've discussed it already, that they're looking at Vision 2030, they're looking at smart cities, they're really jumping into digital identity and AI systems and so on. So, but it doesn't actually have the equivalent of the EU AI Act that we have in Europe at the moment. Um, and so it doesn't have a kind of the PDPL, as well as a data protection law, doesn't have a kind of standalone AI chapter, but it still places clear rules around how AI profiling and automated decision making can use personal data. So again, similar like to the GDPR, it doesn't specifically give definitions of AI, but it talks about profiling, it talks about automated decision making. So Saudi Arabia views AI as a major part of its Vision 2030, like we said, and the PDPL is designed to support innovation, is designed to support innovation while also setting boundaries around higher risk uses. So again, we saw that kind of balance in the Indian law last week. And so I think what the PDPL tries to do as well is to try and get that balance right between being innovative, but also protecting the state as well as their citizens. So under the PDPL, any AI system that processes personal data must follow the law's core principles, having a lawful basis, limiting processing to a specific purpose, collecting only what's necessary, so that's data minimization under the GDPR, and ensuring fairness, transparency, and security. These rules apply whether we're talking about basic analytics or advanced machine learning models in fintech, healthcare, and smart cities environments. So it's across the board. Profiling and automated decision making are treated as potentially high risk activities, which, in my opinion, they are. When AI is used to make decisions about people, such as hiring, credit scoring, eligibility assessments, like we have a lot coming from the European Court of Justice in this area, where they're trying to understand what is seen as automated decision making and what's not. There's been a number of cases. Shufa was one of them back in December 2023. There was another one in February of 2024. about decision making and what can we understand as automated decision making. So again, the similar kind of issues are coming up. So hiring, credit scoring, eligibility assessments, or behavioral predictions against around, the EU AI Act would ban some of those behavioral prediction AI systems. Organizations need stronger risk assessments, enhanced safeguards, and some degree of explainability so individuals understand how those automated decisions were made. Individuals have the right to know when automated processing is happening. So they need notification around, it's an AI system that's processing their data. And in some cases, the right to challenge or correct decisions made solely by algorithms exist. The PDPL doesn't have a direct equivalent of the GDPR's Article 22, like we said before, but the expectation is similar. Important automated decisions should not be completely opaque or unchecked. So you have to have that human in the loop again, like with the GDPR. So biometric data adds another layer of obligation. So if you have biometric data, they look at it more. There's more kind of obligations around that. If AI uses facial recognition or voice prints or other kind of biometric identifiers, the PDPL classifies this as especially high risk. That means stricter security controls, access rules, retention limits, and in many cases, explicit consent, reflecting both national security. Again, the national security kind of comes up as well as the fundamental or the human rights, and cultural sensitivity. So we're seeing a lot around the government, national security, and cultural differences that we've spoken about throughout the podcast. Compared with the GDPR, the PDPL is slightly more governance driven. The GDPR frames automated decision making primarily around individuals' rights, whereas the PDPL blends that with Saudi Arabia's national data sovereignty model, meaning some AI uses may face stronger central oversight. So in short, the PDPL allows AI it does allow AI profiling, but it regulates them through a principle-based, risk-based approach. Organizations must stay transparent. They have to justify their data use, protect sensitive data and biometric data, and maintain human oversight. So again, it is quite close to the GDPR. There are differences, and I would say philosophical differences as well, but it wouldn't be a huge jump for somebody that's been working in the GDPR to work with this law, or to be compliant with the law as well. So, okay, so the next question then for you, Katie, is does the PDPL require organizations to appoint a data protection officer? So again, we saw last week in India that a data protection officer only needs to be appointed when the data fiduciary is seen as significant. So for significant data fiduciaries, how about in the PDPL? What's that like?
So yeah, some again, kind of like the Indian law, some controllers are going to need to appoint a DPO, and that's provided for under Article 30. But there are conditions. So the conditions are where a company carries out large scale monitoring, handles sensitive personal data as a core activity, or operates as a public entity with significant processing responsibilities. So the the Saudi Data and AI Authority has published a couple of kind of guiding literatures here. So they said to determine if you fall under one of these categories, um, consider things like the number of data subjects you handle, the actual volume of the personal data, what's the type of personal data, what's the geographical scope of your processing, and what are the categories of data subjects that you handle. So that's the kind of things to consider if you're asking, do we carry out large scale monitoring? Um,
Okay, so
or
it's
do
similar. It's kind of similar to the Indian law then, is it? So it's only when there's high
yeah,
risk processing taking place.
yeah, basically, or public entity with significant responsibilities. So I suppose that could you could kind of use the same guidance there. Or if handling sensitive personal data is a core activity, so again, financial institutions, um, and stuff
Healthcare,
like
hospitals, and so on. Yeah.
yeah. Um, so they need to document their appointment of a DPO, um, whether they're an internal employee or external. They don't need to be internal, and so the DPO's responsibilities, very much like the GDPR, monitoring compliance, advising on obligations, training staff, point of contact for the SDAIA, um, and there is guidance out there of like what kind of qualifications a DPO should have. So there's a few considerations they put out there. They need to have the appropriate academic qualifications and experience. They need to have a knowledge of risk management practices, knowledge of the regulatory requirements, so knowledge of the law. Interestingly, they need to be an honest. They need to be a person that demonstrates honesty and integrity. So they also can't have been convicted of any offence involving dishonesty or a breach of trust. So those two considerations seem to be kind of independent of each other. So the honesty and integrity, and then not been convicted of any offence involving dishonesty or a breach of trust. So that's to me that's a nice addition. But I'd just love to know what way they're going to consider whether someone is honest, and the integrity and honesty of person, or just be interest.
Maybe it's a
If
background check or something they may have to do.
Yeah, true. I That's just my personal. I just like to know the kind of thought
Mm.
patterns of whoever's appointing them, of what they are going to be. Is there going to be criteria? Is there going to be like a code of practice? And maybe there's more out there that, but yeah. So they're conceptually similar, but it is a bit more like the Indian DPDP than the GDPR when it comes to the appointment of a DPO.
I think that's an interesting consideration as well, that they look for a trustworthy individual. They may check their background to see if they have any kind of criminal record or kind of any kind of wrongdoing. It kind of reflects the importance that they put on data and personal data.
Yeah, yeah,
Yeah. So like somebody in Europe said, data is a new oil. So I suppose, especially for Saudi Arabia, important to protect personal data like oil.
yeah. I think it's another to me. It's another example of how they keep kind of considering personal data in more of a community based understanding rather than individualistic, because it keeps coming back, thinking about not just the effect on the individual, but kind of the broader effects on larger groups of people, you know.
Absolutely. And the country itself,
Hmm.
and
Yeah,
the state, it's very kind of emphasized in the law, I would say.
yeah. Nice to note those differences. But we'll move on to the next question here for you, Maria. What counts as a personal data breach? So what is a personal data breach, and what do organizations need to do?
Okay, thanks, Katie. So I think this is really an interesting area as well, because a personal data breach under the PDPL is defined very broadly. It's not just about hackers trying to hack into the organization. It includes any kind of incident or accidental or intentional breach of personal data as well that leads to loss or alteration or disclosure or unauthorized access to personal data. So it could actually be also internal, like if somebody internally, like a nosy person checking somebody's health record, or something like that would be seen as a breach as well. So a cyber attack counts, of course, but so do everyday mistakes like emailing data to the wrong person within the organization, losing a laptop, misconfiguring a cloud service where personal data is breached, or exposing within the cloud environment as well, or exposing information through poor access controls to employees that shouldn't have access to that kind of personal data. So that's really interesting, you know. And again, I think that, like you say, it might go back to the kind of community or cultural thing about exposing personal data to people within the community that shouldn't have access to that data. You know, like you say, it's private, not just out for protecting people from outside the country, but it seems to be to protect people from even people from in the culture or within the community, you
Yeah.
know. So there seems to be a trend there. So the PDPL focuses on the likelihood of harm. If the incident could affect someone's privacy, their dignity, which is important and interesting, financial security, or their human rights, the organization must treat it as a breach and take action. This reflects Saudi Arabia's emphasis on trust. Again, that's coming up again. Strong governance around national data assets. So when a breach occurs, the organization must notify the Saudi authority or the SDAIA, the regulator, as soon as the organization becomes aware of the breach. There's no fixed kind of 72-hour rule like we have in the GDPR, but the expectation is, make sure it's prompt reporting, especially when sensitive or high-risk data is involved. If the breach is likely to cause harm to the individuals, the organization must also notify the individuals of the breach and explain what happened, what data was exposed, and what steps they should take to protect themselves. So again, you have a similar kind of procedure as the GDPR, but kind of more of an emphasis on protecting the individual from not just external threats, but also within the community or even within their workplace, you know. So the PDPL also requires immediate remedial action, similar to the GDPR, containing the breach, preventing further exposure, restoring data if possible, and reviewing internal safeguards to avoid repeat incidences. So again, the breach procedure is very similar to the GDPR. Organizations also document the response because the Saudi authority the regulator may request evidence of how the incident was handled. So compared to the GDPR, the overall structure is very similar. Both require reporting, transparency, and mitigation. But again, the PDPL places emphasis on central oversight. The supervisory authority, or the SDAIA, has stronger authority to intervene and impose controls or restrict processing in higher risk situations. Breaches include any incident that compromises personal data, and organizations must report it or notify individuals if harm is possible, similar to the GDPR. So, Katie, this brings us to our last question, which is for you. And the question is, what are the penalties for non-compliance, and how does the PDPL enforce non-compliance?
So it does come with quite substantial administrative fines, up to 5 million Saudi riyal, with the potential for doubled penalties if an organization commits repeat violations. So quite a good deterrent there. But they also have a couple of criminal penalties of imprisonment, fines for unlawful disclosure of sensitive data or illegal cross-border data transfers. So quite a bit more severe there. The enforcer of these penalties is the SDAIA, and the regulators have shown willingness to enforce, especially in situations of national security and public trust. So that's an almost, national security, public trust, that's in, God, every second question nearly that we went through. So it's very important to them.
And it's also evidenced by the fact that they are willing to put people in prison if they breach.
Oh yeah.
If they breach the law.
especially for the illegal cross-border transfers that they can ensue with criminal penalties. So it is quite different to the GDPR in that sense, actually. GDPR relies mainly on administrative fines. That's it. I mean, criminal liability, you can't, get a bigger, you can't really,
No,
I don't know what I'm saying.
absolutely.
You
And
can't
I
get a
think that
strong.
probably, yeah. And that I think that probably falls on the leaders, like I would say that would probably be the CEO or managing
Mm,
directors or the board or so on of
hopefully not the
organizations.
DPO.
Yeah, hopefully not. I wonder, does the DPO have that independence like it does
Mm.
under the GDPR? That might be an interesting question to ask. So the DPO under the Saudi PDPL does not have the same level of statutory independence as the GDPR DPO.
Okay.
It's not in the same way. Under the GDPR, the data protection officer is a legally protected role. They must act independently and cannot be dismissed, as we know. But under the Saudi PDPL, the level of independence isn't explicitly built into the law. So the PDPL does allow organizations to appoint someone responsible for privacy oversight, but it doesn't include the GDPR style protections around independence, job security, and guaranteed access to leadership. Instead, the PDPL takes a governance driven approach. The person overseeing data protection must ensure compliance with the law, support internal controls, manage breach notifications, and coordinate with the Saudi regulator, but they operate within the organization's normal management structure. So the version of a DPO under the PDPL is more of a compliance coordination role rather than an independent statutory officer. That's interesting.
That is, yeah.
And that could have different implications for the DPO and how they conduct themselves in the organization,
Yeah, that kind of honest integrity consideration is quite important in light of that.
Conflict of interest could be an issue for DPOs taking up the role of a DPO in the kingdom of Saudi Arabia, because if they don't have that protection, they won't feel as confident to call out wrongdoing,
Yeah.
So the integrity of the individual is very important then in that respect. Great. So thanks, Katie, for that. That was a really interesting final question. So that brings us to the end of our walkthrough of the Saudi PDPL. Hopefully this discussion gives you a clear understanding of how the law works, where it aligns with the GDPR, and where the key differences lie. Thank you, Katie, for joining me again today. And thank you to our listeners for tuning in. Don't forget to subscribe, and we'll see you in the next episode as we continue to explore our global privacy, data protection, and AI governance podcast.
Thanks, Maria.
Thanks, everyone. Thanks, Katie. Take care.